If I may, Mr. Chair, I'd like to deal with a general topic before proceeding further and dealing with the particular witnesses and evidence to be led. And it's to do with a theme that will pervade the presentations made to you in evidence and the submissions in due course to be made before you, Mr. Chair. And it deals with the essence of constitutional democracy and its potential breach, which may be referred to in evidence and may require submissions and findings in due course. And in our submission, Mr. Chair, the essence of a representative democracy, and in particular a constitutional democracy such as ours, is that the people entrust to the lawmakers, entrust to the executive, and entrust to the judiciary the responsibility to act in their best interests. And in particular, they should be held accountable if they fail to do so. In summary, and again I refer to the article by Peter Labuskaghni, the essence of representative government is that the elected government acts in the interests of those that it governs. Essential to that relationship is that officials can be held accountable when they fail to act according to this obligation. And in particular, they can be called to account if they act fraudulently and corruptly. We will submit in due course, Mr. Chairman, that the ability of the populace, the people in general, to hold an elected government accountable depends in large measure upon them being properly informed and upon them receiving proper and accurate information. It also depends on people being held criminally accountable for unlawful acts. Part of what this commission will be asked by the legal team to examine, Mr. Chairman, is whether there were attempts to take control of the public narrative and discourse, and if so, whether this was a manifestation of state capture in South Africa. What, the question will be asked, was the role of the New Age newspaper? What, the question will be asked, was the role of Bell Pottinger? Did the state, it will be asked, support the New Age newspaper? And if so, why? To the extent that such support might be shown, the further question is, was this simply to allow individuals and entities access to state funds, or was it to do with the control of the public narrative, or was it to do with both? And very importantly, a theme that will be explored throughout is, have any wrongdoers that might be shown to be such been held to account both within and outside of government? To the extent that the Commission may find that they have not been held to account, further questions can be asked. Is this inefficiency, or is it the result of some other cause? Or, possibly, is it also a manifestation of state capture? The question arises, will it be necessary to call our government and its law enforcement agencies to account as well? Returning to the terms of reference then, Mr. Chair, it is to be noted that these terms of reference may be added to, varied, or amended from time to time. That is the prerogative of the President. The legal team may well make submissions to the Chair in this regard, when and to the extent necessary and to the extent appropriate. Can I get to the next slide? Thank you. Dealing then with the final stages in time and the findings, report and recommendations as dealt with in the terms of reference. The first part of the terms of reference place various obligations on the Commission. It shall inquire into, it shall make findings, it shall report, and finally make recommendations. Term of Reference 7 expands on this duty to a degree and records that the Commission shall, where appropriate, refer any matter for prosecution, further investigation, or the convening of a separate inquiry to the appropriate law enforcement agency, government department, or regulator regarding the conduct of certain persons. Mr. Chairman, it is clearly too early to state with any certainty what the investigations will produce, the detail and extent of the evidence that will ultimately be led, and therefore what submissions the legal team will make to the Chair. But what can be stated with a reasonable degree of certainty is that the legal team submissions in regard to the findings, report and recommendations that the Chair might make will address the following questions. And in the summary, I repeat, Mr. Chair, some of the questions referred to earlier on in this address. Firstly, did state capture exist? Does it still exist in the second place? If so, how can it be dealt with? Has the evidence shown a series of isolated or disconnected occurrences? Or has the evidence shown an organized and comprehensive plan that could be labeled state capture and that has informed all or some of these occurrences? Sixthly, has the full extent of any plan of state capture and its implementation been proven? Seventhly, to the extent that harm has been done to the state, to government, to state entities and state-owned entities, can that harm be remedied? If so, how? Lastly, what can be done both in the short term and the long term to prevent a recurrence of what might be found to have occurred and the effects that it might be found to have had? Is prosecution of offenders enough, or is more required? Should consideration be given to legislative amendments, to policy review, to restructuring and reorganization in public entities and their governance? Do provisions regulating procurement need overhaul? Or is it the persons rather than the processes that might be found to be at fault? If the processes are not at fault, how can compliance nevertheless be ensured? In regard to accountability, we might mention briefly that, of course, our criminal law deals with wrongdoing mainly through the prosecution of individual criminal wrongdoers. However, wrongdoers, if found to have acted in concert, may also be called to account as a collective. The Chair, Mr. Chairman, will no doubt in the future consider reference for prosecutions, further investigations, or separate inquiries. And these may, if appropriate and in appropriate submissions and in appropriate circumstances, include the power to make use of the provisions of Section 204 of the Criminal Procedure Act in appropriate circumstances. And very briefly, Section 204 of the Criminal Procedure Act directs that if witnesses answer frankly and honestly all questions put, they shall be discharged from prosecution with regard to the offence so specified and with regard to any offence in respect of which a verdict of guilty would be competent upon charge of relating to the offence so specified. Now, of course, Mr. Chair, this Commission has no power to direct the use of Section 204, but if the Commission has the power to direct prosecutions, perhaps in appropriate circumstances, it might be persuaded by whomever concerned in an appropriate circumstance to recommend the lesser remedy provided for in Section 204. But again, it must be stressed that no decisions have been made in this regard, and it's all subject to appropriate submissions and appropriate consideration by yourself, Mr. Chair. At the stage that factual evidence is complete then, Mr. Chair, the legal team may be asked by the Chair to lead expert evidence on recommendations, particularly in relation to terms of reference 1.5 and 1.9, the nature and extent of corruption as has been dealt with above, or it may lead such evidence on its own initiative. Dealing now briefly and in summary, Mr. Chair, with the evidence actually to be led in the next few weeks. Later today, Advocate Norman will make a presentation dealing with reports already received by the Commission and in the public domain. A summary of the content of these documents and the basis of their admission will be dealt with by Advocate Norman. These reports may be admitted for what they are and dealt with in evidence, particularly to the extent that evidence is necessary to deal with any controversy that may be contained on a factual basis and otherwise in these reports. Over the past few years, and these will be dealt with in detail, Mr. Chairman, there have been a number of reports and studies into allegations of state capture. These include the Public Protector's Report, Parliamentary Committee reports, reports commissioned by Treasury, reports commissioned by state-owned entities and others. The Commission may be asked to have some regard to those reports, but the legal team will not, without further evidence, hold them out as being correct. The legal team may propose that the Commission should not undertake work which will be a repetition of work already done, particularly where there is little or no controversy in relation to facts found and conclusions drawn. But, Mr. Chair, where there is controversy or possible controversy, the legal team, together with the investigation team, will inevitably have to do its own investigative work, and thereafter the Commission will be asked to make its own findings. There will also, towards the end of next week, Mr. Chairman, be some expert evidence, by your leave, in relation to state capture as a concept generally. We know, Mr. Chair, that state capture is not a concept or practice unique to South Africa. As will be explained in the evidence of experts, the phenomenon has manifested in the past in many other countries, still does. It has manifested too in countries which may be described as democracies in transition in particular. Experts will deal with these phenomena. A particular expert may be called more than once, and more than one expert may be called to deal with the various aspects of the Commission's work in this regard. But we stress, Mr. Chair, that the fact that reference will be made to state capture in other democracies, particularly those in transition, is not to diminish its significance in South Africa. On the contrary, we may learn from a comparative analysis. Its prevalence and the apparent ease with which it appears in other democracies may sharpen our own vigilance in South Africa. We will also be assisted by the experience of other countries who have had to deal with state capture, with their successes and with their failures. Then there will be evidence on procurement, Mr. Chairman, and that will take place this week. The legal team, Advocates Tabashi and Norman, will seek to lead the evidence of the Acting Chief Procurement Officer of National Treasury. The purpose of this evidence will be to place before the Commission matters relating to procurement prescripts and policy. Procurement prescripts and policies will be submitted, central to the Commission's terms of reference. Some of the questions which the legal team will in due course seek to deal with are, firstly, is the procurement framework prevailing in our country comprehensive and adequate? Is it possible to manage the existing system in such a way as to prevent abuse? Has state capture, insofar as it might be shown and proven, been enabled or permitted by weaknesses in the procurement framework? Simply put, Mr. Chair, is it the people or the policies or both? And how best are any shortcomings in the procurement framework and its management addressed? Mr. Chair, if I could introduce the first one. An interactive slide that will ultimately appear on the Commission website, which fundamentally outlines the structure of the executive from the President to boards and executives of departments and state-owned entities, particularly state-owned entities. The legal team will commence leading evidence on the issues raised in items 1.1, 1.2, and 1.3 of the terms of reference. The witnesses will be led by Advocate Mokoena, Advocate Sello, and myself. The witnesses to be called will be Ms. Mentor, Mr. Jonas, Minister Neni, Minister Gordhan, and others. It will deal with the alleged undue influence by private interests in relation to the President and Cabinet appointments. What should be noted in this regard, Mr. Chair, is that this evidence will not necessarily be entirely consistent. Our mandate is not to prove a particular version of events. Our mandate is expressly to investigate the veracity or truth of allegations relating to Mr. Jonas and Ms. Mentor. The resolution of disputes of fact that might emerge falls within the province of the chairperson. The legal team is also of the view, Mr. Chairman, that appointments cannot be properly interrogated and understood without having regard to their preceding dismissals and the circumstances in which these took place. These matters too will be covered in evidence. As stated, Mr. Chair, item 1.6 of the terms of reference covers a range of issues. It deals with the illicit provision of government services in favour of private interests. The team leading the evidence under this head is led by Advocate Maleka and includes Advocate Hofmeyr and others. Amongst the issues that will be dealt with in this session, Mr. Chair, and there will be other issues dealt with later, is the alleged attempted and actual appropriation of government advertising budget for the benefit of the New Age newspaper and possibly the ANN 7 television channel too. The legal team will also seek to present evidence of a witness from Government Communication Information System, and that witness will testify about the value structure of the institution from its inception to date, the procurement processes within the institution, and how those values and processes were allegedly undermined when the institution fell under the jurisdiction of Minister Mutambi. Then we will deal in this session too with protective steps taken, perhaps unlawfully, perhaps corruptly, perhaps improperly, perhaps all three, in relation to members of Cabinet or Cabinet interfering in the attempts by private banks to close bank accounts of Gupta, the Guptas, Gupta Associates, and Gupta-related companies. The question we are required to answer, or to lead evidence in respect of, is whether any minister or deputy minister acted unlawfully, corruptly, or improperly in intervening when several banks closed or sought to close the bank accounts of the Guptas or Gupta-related companies. Then we will get to phase 2 of the Commission's work. Evidence would be led at a later stage in this Commission's proceedings by your leave, Mr. Chair. And this work will hopefully enable the Commission to benefit directly from the work of the investigation team recently appointed and under the direction of Terence Nombembe. There are, Mr. Chair, a number of state-owned entities whose affairs the terms of reference require, in the submission of the legal team, the Commission to investigate and lead evidence on. These include Eskom, that team will be led by Advocate Maleka; Transnet, that team will be led by myself; Denel, that team will be led by Advocate Kabashi; South African Airways, that team will be led by Advocate Hofmeyr; the South African Broadcasting Corporation, a team led by Advocate Norman; and the Public Investment Corporation, team led by Advocate Buthelezi. There will be others as well. The Free State Vrede Dairy Farm issue, sometimes referred to as the Estina issue, will also be dealt with under the management of Advocate Kabashi. together with certain other issues in provinces and municipalities. Many of the issues relating to, for example, state-owned entities are already in the public domain, as will become apparent when Advocate Norman addresses you. We will, of course, not ignore this information as a legal team, Mr. Chair, but the investigations will no doubt not be limited to information at present in the public domain. And in relation to state-owned entities, government departments, procurement, and the alleged diversion of state resources from its intended goals to elicit private interests involves a number of discrete issues that need to be dealt with. And these matters might include, but not limited to, Mr. Chair, alleged undue interference in the appointment of state-owned entity boards and executives, alleged breaches which might have resulted in standards of corporate governance, and ultimately alleged irregular procurement practices. To the extent that procurement irregularities have resulted in financial loss or prejudice, the legal team will seek to present to the Commission evidence related to the extent of that loss if proven, and the extent to which the socio-economic objectives enjoined by the Constitution have been undermined or simply not met. As far as recommendations are concerned, the legal team will consider submissions to the Chair in regard to ensuring proper corporate governance and in particular recommendations relating to procurement management. Mr. Chair, I've already dealt with requirements placed on the Commission by terms of reference 1.5 and 1.9. As already stated, in the view of the legal team, there's a clear need to rely on detailed research and detailed commentary. As already stated, the Commission will of course conduct its own research and investigations and into corruption generally in Schedule 2 institutions and at all levels of government. But in our view, the reliance on research conducted or to be conducted outside the Commission cannot be underestimated. In the view of the legal team, the Commission will, in addition, no doubt require expert assistance in regard to recommendations in dealing with the findings that might be made in relation to corruption generally. Then to conclude with a few remarks, Mr. Chairman. It may appear from what the legal team has put before you thus far that the work of the Commission is intended only to uncover alleged wrongdoing on the part of persons within government and persons outside of government, and to ensure that they are called to account for their alleged deeds insofar as such may be proven before you. But to regard the work of the Commission in this light alone would be to ignore at least one of its more important aims, Mr. Chair. In the leading publication on public inquiries by Beer QC, references given, the learned authors highlight a major purpose of a public inquiry as being to restore public trust and confidence in government. To the extent that this Commission might show that this country has been beset by the phenomenon of state capture, the obvious demand on the Commission will be to recommend what needs to be done to address such a finding. Mr. Chair, experts on state capture that we have consulted thus far tell us that South Africa is exceptional amongst post-colonial democracies in the manner in which the international phenomenon of state capture has been responded to by our judiciary, by aspects of government, by our Chapter 9 institutions, by civil society. It is exceptional in the way that this phenomenon has been responded to. It's exceptional in the way it has been and continues to be investigated and dealt with. So if in continuing this work, viable solutions can be examined and proposed in its recommendations, Mr. Chair, we submit to you that this Commission can indeed play a positive role, not only for South Africa, but internationally as well. that is the legal team's opening. Thank you.
Thank you very much, Mr. Pretorius, for that opening statement. You indicated that the next item would be the presentation of reports, if I remember correctly, by Advocate Norman. Is that correct?
Yes, subject to one qualification, Mr. Chair, and that is that there are various legal teams eager to place themselves on record, and perhaps you may consider a short adjournment to consider that. Mr. Maleka will be dealing with this aspect of this morning's proceedings, and I'm not sure whether you would want to meet these teams in chambers prior to continuing to allow them to place themselves on record, or how you would wish to deal with it.
Do you know how many there are in terms of?
Chair, there are many. My respectful suggestion is that before you even meet them in chambers or otherwise, invite them to place their names on record, who they appear for, and what sort of directions they may invite you to make with reference to the interest they represent.
Mr. Pretorius, maybe it would be better to let them come forward and say what they are asking me to do. And once I have an idea, then maybe I can meet them in my temporary chambers here without when they indicate what they would like me to do for them or their clients. At this stage, I'm not asking for any elaboration. I would be wanting just an indication. I think maybe let's do that. Do you have something to say about taking that direction, Mr. Pretorius?
No, as you please, Mr. Chair. I would just suggest that we adopt the court procedure to avoid chaos of legal representatives introducing themselves in order of seniority.
Well, I think I'm going to then say, let me take an adjournment now, and Mr. Maleka, Mr. Pretorius, or the Commission's legal team, or some of them, can then bring those legal teams over to my chambers so they can introduce themselves first, and then we'll take it from there. We will come back here.
Yes.
Is that
Thank
fine?
you.
Yes.
Sure.
So we'll take a short adjournment now, and it should take not more than 10 minutes. Thank you. We adjourn.